Miss Martinez, I see you brought your emotional support animal into my courtroom. This is not a pet-friendly place.
Your Honor, Ranger is a fully trained service dog.
Judge laughs at disabled veteran and her service dog in court, but has no idea who's about to walk in. The wheelchair's quiet squeak echoed through the oak-paneled courtroom as Captain Lisa Martinez, U.S. Army retired, positioned herself at the plaintiff's table with her German Shepherd Ranger beside her. Judge Harold Brennan barely glanced up from his paperwork as he surveyed the disability discrimination case before him, his expression already suggesting skepticism about the woman whose service-connected injuries had cost her the use of her legs, but not her dignity. "Ms. Martinez," Judge Brennan drawled with barely concealed amusement, "I see you've brought your emotional support animal to my courtroom. This isn't a pet-friendly establishment." His smirk drew nervous laughter from the gallery as Ranger's alert posture indicated his detection of Lisa's rising stress levels, the same hypervigilance that had once made her the most decorated combat medic in her battalion. What Judge Brennan didn't know was that in exactly 3 minutes, someone would walk through those courtroom doors whose presence would transform his arrogance into the most humbling experience of his 30-year judicial career. The Superior Court of Riverside County, California, 2025. Judge Harold Brennan's courtroom was his kingdom, where 30 years on the bench had cultivated an attitude of absolute authority, unchecked by humility or compassion. The oak-paneled chamber, with its brass fixtures and leather-bound law books, reflected Brennan's old-school approach to justice, rigid, traditional, and suspicious of anything that didn't conform to his narrow understanding of how the world should operate. Captain Lisa Martinez embodied the courage and sacrifice that civilian society often failed to recognize or appreciate. At 34, she carried the invisible wounds of 3 combat deployments to Iraq and Afghanistan, where her role as a forward-deployed combat medic had saved dozens of lives while earning her a Bronze Star with V Device 2 Purple Hearts and the respect of every soldier who'd served under fire. The IED explosion that had severed her spinal cord had ended her military career, but not her commitment to serving others. Ranger represented the pinnacle of service dog training, a German Shepherd whose 2 years of specialized education had cost $50,000 and whose capabilities extended far beyond standard assistance animals. His training encompassed PTSD episode management, mobility assistance, medical alert responses, and the kind of protective instincts that made him invaluable for a veteran whose combat experiences had left her vulnerable to crowds, loud noises, and confrontational situations. Their partnership had been forged through 18 months of intensive training that taught them to function as a single unit. Ranger could detect Lisa's anxiety attacks minutes before they manifested, guide her wheelchair through crowds that triggered her combat-related hypervigilance, and provide the deep pressure therapy that prevented full PTSD episodes. His presence was medical necessity rather than emotional comfort, though the bond between them transcended professional relationship. The case that brought them to Brennan's courtroom was straightforward but representative of systematic discrimination faced by disabled veterans. Lisa's employer, a major defense contractor, had terminated her after she'd requested accommodation for Ranger's presence in their facility. Despite federal law clearly protecting service animal access, the company had claimed that dogs violated their security protocols, a position that was legally indefensible but practically devastating for a veteran whose livelihood depended on work that utilized her military experience. Judge Brennan's prejudice against service animals reflected broader societal ignorance about veteran disabilities and accommodation requirements. His judicial philosophy emphasized common sense over legal precedent when it came to disability law, while his personal experience was limited to the kind of obvious physical disabilities that fit his preconceptions about what handicaps looked like and how they should be managed. The broader context was a legal system struggling to catch up with evolving understanding of veteran disabilities and service animal partnerships. While federal law protected service animal access implementation often depended on individual judges' knowledge and attitudes, creating situations where legal rights were subject to personal prejudices rather than established precedent. The gallery contained a mixture of supporters and skeptics, with veteran advocates sitting alongside defense contractor representatives whose financial interests were threatened by accommodation requirements that could set expensive precedents. The case had attracted attention from disability rights organizations and military support groups who understood that the outcome would influence veteran accommodation nationwide. The collision between Lisa's dignity and Brennan's arrogance was building toward a confrontation that would test whether federal disability law meant anything when it conflicted with judicial prejudice, and whether one veteran's courage could overcome institutional bias that had been entrenched for decades. The morning had begun with the kind of routine humiliation that disabled veterans learned to expect from institutions that paid lip service to supporting those who'd served. Security officers at the courthouse entrance had questioned Ranger's legitimacy despite his official service vest and Lisa's comprehensive documentation, while courthouse staff had directed them to a special entrance that was actually a service corridor designed to hide disabled individuals from public view. Lisa's attorney, Rebecca Chin, was a disability rights specialist whose practice focused on service animal discrimination cases. Her opening statement was precise and legally unassailable. Your Honor, Captain Martinez is seeking reinstatement to her position with Meridian Defense Systems accommodation for her service animal as required by federal law and compensation for damages resulting from illegal termination based on her disability. Judge Brennan's initial response revealed the depth of his ignorance about both military service and disability law. Ms. Chen, I understand your client has some challenges related to her military service, but this courtroom has functioned perfectly well for 30 years without animals, and I see no reason to change that now. The first indication of trouble came when Brennan directed courthouse security to evaluate whether that animal poses a safety risk to courtroom proceedings. The request was both legally inappropriate and personally insulting, treating Ranger as a potential threat rather than essential medical equipment that Lisa depended on for stability and safety. Your Honor, Lisa interjected, her voice carrying the calm authority that had once directed battlefield medical operations. Ranger is a fully trained service dog whose presence is protected by federal law. He poses no threat to anyone and is essential for managing my service-connected disabilities. Brennan's response was dismissive and revealing, Ms. Martinez, I've been a judge for 3 decades, and I've seen every excuse and accommodation request imaginable. What I haven't seen is compelling evidence that dogs belong in legal proceedings designed for serious adult business. The insult was both personal and institutional, reducing Lisa's combat-tested capabilities to childish need for comfort while ignoring federal statutes that protected her rights. Rangers' alert behavior indicated that Lisa's stress levels were rising toward thresholds that could trigger PTSD episodes, his training recognizing physiological changes that courtroom observers couldn't detect. Furthermore, Brennan continued with growing confidence in his authority. I question whether someone who requires an animal for emotional support possesses the mental competence to participate effectively in complex legal proceedings. The statement was legally actionable and medically ignorant, but it reflected attitudes that many disabled veterans encountered in civilian institutions. Lisa's response was controlled but firm, drawing on military training that had taught her to maintain composure under hostile fire. Your Honor, I am a decorated combat veteran whose service record includes 3 deployments and recognition for heroism under fire. My service dog is trained medical equipment, not emotional support, and my competence has been proven in circumstances far more challenging than this courtroom. But Brennan's prejudice was too deeply rooted to be challenged by facts or legal arguments. Ms. Martinez, your military service is appreciated, but this is a civilian court operating under civilian rules. If you cannot participate without assistance, perhaps we should consider whether you're capable of representing your own interests. The suggestion that Lisa might be mentally incompetent was the final insult that would have consequences Brennan couldn't imagine. But before Lisa could respond, the courtroom doors opened to admit someone whose presence would transform the entire proceedings and expose Brennan's ignorance to scrutiny he'd never experienced. The man who entered was in full military dress uniform, his bearing unmistakably command-level authority, his chest decorated with ribbons that spoke of service in the world's most dangerous places. The courtroom fell silent as General Patricia Hayes, commanding general of the U.S. Army Medical Command and Lisa's former commanding officer, approached the bench with a kind of presence that made even federal judges reconsider their assumptions about authority and respect. General Hayes's entrance was a masterclass in military bearing, applied to civilian authority, her 4-star insignia immediately recognizable to anyone with knowledge of military hierarchy, while her presence commanded respect that transcended jurisdictional boundaries. At 57, she was the highest-ranking medical officer in the U.S. Army, whose career had encompassed battlefield surgery, medical research, and policy development that had saved thousands of lives throughout her service. Your Honor, I am General Patricia Hayes, Commanding General of the U.S. Army Medical Command. She announced, her voice carrying the kind of authority that had directed medical operations in combat zones around the world. I apologize for the interruption, but I believe this court is discussing Captain Lisa Martinez, who served under my command and whose service record requires clarification. Judge Brennan's arrogance faltered as he found himself facing someone whose rank and reputation exceeded his own authority, but his recovery was swift and defensive. General Hayes, while I appreciate your service, this is a civilian courtroom where military rank holds no jurisdiction. We're conducting legal proceedings according to established civilian law. The general's response was precisely calibrated to demonstrate respect for civilian authority while establishing facts that would reshape the entire case. Your Honor, I have no intention of overriding your judicial authority. However, I believe you may be operating with incomplete information about Captain Martinez's service record and the medical necessity of her service animal accommodation. What followed was a systematic dismantling of every assumption that Brennan had made about Lisa's capabilities and needs. General Hayes produced a leather portfolio containing Lisa's complete military medical records, commendations, citations, and documentation that painted a picture of heroism and sacrifice that civilian minds struggled to comprehend. Captain Martinez served 3 combat deployments as a forward-deployed combat medic. General Hayes began her words carrying the weight of personal knowledge and professional respect. During her second deployment, she single-handedly established a casualty collection point under enemy fire, treating 17 wounded soldiers while calling in medical evacuation helicopters. Her actions saved lives that would have been lost without her courage and medical expertise. The courtroom's atmosphere shifted dramatically as General Hayes continued documenting Lisa's service record. The Bronze Star with V device for valor in combat, the Purple Hearts for wounds received while treating others, the Combat Medical Badge that signified service under fire, each award represented circumstances that most civilians could never imagine surviving, let alone mastering. The IED explosion that ended Captain Martinez's active duty career occurred while she was responding to a casualty call. The general continued, her voice carrying the pain of someone who'd lost too many good soldiers to senseless violence. Despite her own severe injuries, she continued treating wounded personnel until medical evacuation arrived. Her actions that day exemplified the Medical Corps motto, "To conserve fighting strength." Judge Brennan's discomfort was visible and growing as he realized that his dismissive treatment of Lisa had been witnessed by someone whose opinion could destroy his reputation if she chose to make their conversation public. His attempt to reassert authority revealed the depth of his misunderstanding. "General, I appreciate Captain Martinez's military service, but this case involves civilian employment law, not military heroics." The response came not from General Hayes, but from Lisa herself, whose military bearing was now fully evident as she addressed the court with confidence that her commanding officer's presence had restored, "Your Honor, my military service is directly relevant to my civilian capabilities and my need for service animal accommodation. The PTSD and mobility limitations that resulted from combat injuries are medical conditions that require specific accommodation, not character flaws that disqualify me from employment." But General Hayes wasn't finished with her testimony about Lisa's qualifications and the medical necessity of Ranger's presence. "Your Honor, Captain Martinez's service dog represents the most advanced therapeutic intervention available for combat-related PTSD and mobility limitations. The training program that certified Ranger costs over $50,000 per animal and has waiting lists that extend for years because of proven effectiveness in managing severe combat trauma. The education that followed was comprehensive and embarrassing for Brennan, whose ignorance about veteran disabilities was being exposed in excruciating detail. General Hayes explained the neurobiological effects of combat trauma, the medical necessity of service animal partnerships, and the federal legal framework that protected accommodation rights for disabled veterans. Judge Brennan, General Hayes said with quiet authority that carried more weight than any gavel, "Captain Martinez earned the right to civilian accommodation through service that most people cannot comprehend. Her request for reasonable accommodation is not just legally required, it's morally demanded by the sacrifice she made in service to this nation. The courtroom gallery, which had been murmuring throughout the general's testimony, erupted in applause that Brennan was powerless to control. Veterans, disability advocates, and legal observers understood that they were witnessing a transformative moment where military authority was being used to protect rather than intimidate, where institutional power was being applied to support rather than suppress individual rights. The tide had turned completely with Brennan now facing pressure from the highest levels of military leadership, while his treatment of Lisa was being documented by court reporters whose transcripts would become public record. The judge who had mocked a disabled veteran was now facing consequences that could define the remainder of his judicial career. The revelation of Lisa's military record should have been the end of Judge Brennan's dismissive attitude, but institutional pride often breeds the kind of defensive stubbornness that transforms embarrassment into anger. Rather than acknowledging his error, Brennan doubled down on his authority in ways that would prove professionally catastrophic and personally humiliating. General Hayes, I appreciate the information you've provided, Brennan declared with forced confidence, but this court operates under civilian law, not military protocol. Captain Martinez's service record, while commendable, doesn't change the fact that this courtroom has procedures that must be followed regardless of individual circumstances. The statement was both legally wrong and strategically disastrous, challenging federal disability law while disrespecting military service in front of someone whose influence extended throughout the Department of Defense and veteran advocacy networks. General Hayes's expression revealed recognition that she was dealing with someone whose prejudice exceeded his judgment. But the crisis deepened when Brennan made the decision that would define his legacy. Furthermore, I question whether Captain Martinez's combat-related psychological conditions make her competent to represent her own interests in these proceedings. Perhaps we should consider appointing a guardian ad litem to ensure her rights are properly protected. The suggestion that Lisa was mentally incompetent due to PTSD was not just insulting, but legally actionable, creating grounds for judicial misconduct charges, while demonstrating ignorance about mental health. That was shocking, even for civilian officials. The statement attacked the competence of someone who had made life-or-death medical decisions under enemy fire, whose judgment had saved dozens of lives in circumstances that would have paralyzed most people. Lisa's response was immediate and devastating, her military bearing fully asserting itself as she addressed prejudice that challenged her fundamental dignity. Your Honor, I am a combat-tested medical professional whose competence has been proven under the most extreme circumstances imaginable. My PTSD is a medical condition that requires accommodation, not a cognitive impairment that affects my legal judgment. But Brennan's commitment to his position had passed the point of rational retreat, his judicial ego refusing to acknowledge error that was becoming more obvious with each word. Ms. Martinez, your emotional attachment to your therapy animal suggests a level of dependency that raises questions about your ability to make objective decisions about your own welfare. The insult was comprehensive and legally indefensible, reducing Lisa's medical accommodation to emotional weakness, while questioning her mental capacity based on disability rather than demonstrated incompetence. Ranger's alert behavior indicated that Lisa's stress levels were reaching dangerous thresholds, his training recognizing physiological changes that could trigger full PTSD episodes. General Hayes's intervention was swift and decisive, her military authority now directed toward protecting someone under her care from institutional abuse. Judge Brennan, your statements about Captain Martinez's competence are not only medically inaccurate, but legally inappropriate. You're suggesting that combat-related PTSD disqualifies veterans from legal proceedings, a position that violates both federal disability law and basic human dignity. The confrontation was escalating toward institutional crisis, as Brennan found himself challenged by someone whose authority exceeded his own, while his statements created liability that could destroy his career. The courtroom atmosphere was electric with tension, as observers recognized they were witnessing something unprecedented, a federal judge's prejudice being exposed and challenged by the highest levels of military leadership. The darkest moment came when Brennan, realizing that his position was becoming indefensible, attempted to use his judicial authority to silence criticism. General Hayes, I appreciate your advocacy for Captain Martinez, but this court will not tolerate disruption of legal proceedings. I'm ordering you to take your seat or face removal from this courtroom. The threat to remove a 4-star general for defending a disabled veteran was the final mistake that would end Brennan's judicial career. The gallery erupted in outrage as legal observers, veteran advocates, and media representatives recognized that they were witnessing judicial misconduct of the highest order. Court reporters documented every word while phones captured video that would be national news within hours. Lisa's psychological breaking point came not from Brennan's attacks on her competence, but from watching her commanding officer face disrespect for defending her rights. The woman who had treated casualties under fire began experiencing the kind of PTSD episode that Ranger was trained to manage: her breathing becoming rapid and shallow as memories of combat trauma merged with present circumstances. But Ranger's response was immediate and professional. The German Shepherd moving into position to provide deep pressure therapy, while alert positioning that communicated medical emergency to anyone trained to recognize service dog protocols. His intervention was visible proof of the medical necessity that Brennan had been dismissing, demonstration that accommodation wasn't luxury, but life-saving medical equipment. The crisis was complete. A disabled veteran was experiencing medical emergency caused by judicial prejudice, while the highest-ranking medical officer in the U.S. Army was being threatened with removal for defending someone whose sacrifice had earned institutional protection rather than courtroom mockery. The transformation began when the rear doors of the courtroom opened again, this time to admit a figure whose presence would dwarf even General Hayes's authority. Supreme Court Justice Maria Gonzalez, the first Latina to serve on the nation's highest court, and herself a former military JAG officer, entered with the measured pace of someone whose decisions shaped American law at its most fundamental level. Your Honor, Justice Gonzalez announced with quiet authority that instantly silenced the chaotic courtroom, I am Justice Maria Gonzalez of the United States Supreme Court. I was in the building for meetings with the Ninth Circuit when my staff informed me of proceedings in this courtroom that appear to involve serious constitutional questions about veterans' rights and judicial conduct. Judge Brennan's face went pale as he realized that his treatment of Lisa and General Hayes was now under scrutiny from someone whose opinion could end judicial careers with a single phone call. The hubris that had driven him to challenge military authority evaporated when confronted with someone whose constitutional authority was absolute and whose knowledge of military law exceeded his own understanding of civilian statutes. Justice Gonzalez. Brennan stammered his earlier confidence, replaced by recognition that he was facing career-ending exposure. I was simply maintaining courtroom order while addressing accommodation requests that seemed excessive, given the circumstances. The Supreme Court Justice's response was delivered with the precision that had made her opinions legendary for their clarity and constitutional authority. Your Honor, I've reviewed the audio recordings from these proceedings, and I'm concerned that your comments about Captain Martinez's competence may constitute violation of both the Americans with Disabilities Act and the due process rights of a decorated combat veteran. What followed was a systematic legal education that exposed every error Brennan had made while providing constitutional framework for understanding why his conduct was not just inappropriate, but potentially criminal. Justice Gonzalez's analysis was delivered with academic precision that transformed the courtroom into a law school seminar, where the subject was judicial misconduct and constitutional violations. The suggestion that PTSD disqualifies veterans from legal proceedings violates equal protection principles established in multiple Supreme Court decisions. Justice Gonzalez continued, her words carrying weight that no lower court could ignore. Furthermore, your treatment of General Hayes suggests unfamiliarity with both military customs and the constitutional principle of civilian-military cooperation that defines American governance. The education that followed was comprehensive and humiliating, with Justice Gonzalez explaining federal disability law, military service obligations, and constitutional principles that Brennan should have mastered decades earlier. Her tone was professional, but pointed, making clear that his ignorance was inexcusable for someone with his experience and responsibilities. But the most powerful moment came when Justice Gonzalez addressed Lisa, directly acknowledging her service and sacrifice with the respect that Brennan had failed to provide. Captain Martinez, your service to this nation has earned you not just accommodation, but gratitude. The constitutional rights you defended in combat should protect you in civilian life, and any court that fails to recognize that obligation dishonors your sacrifice. Lisa's response was delivered with military bearing that her PTSD episode had temporarily disrupted, but not destroyed. Thank you, Justice Gonzalez. I didn't serve 3 deployments to have my rights questioned by the civilian institutions I swore to protect. The resolution came swiftly as Brennan, faced with constitutional authority that he couldn't challenge and misconduct that he couldn't deny, issued the kind of comprehensive apology that acknowledged both personal error and institutional failure. Captain Martinez, I apologize unreservedly for my treatment of you and your service animal. My comments were inappropriate, legally wrong, and personally insulting to someone whose sacrifice deserves recognition rather than skepticism. But Justice Gonzalez wasn't finished with a constitutional education that would reshape how this case and similar proceedings would be conducted. Your Honor, I recommend that this court immediately implement mandatory training on veterans' rights and disability accommodation for all judicial personnel. The constitutional principles at stake here extend far beyond individual cases to encompass fundamental questions about how American institutions treat those who've served in uniform. The institutional changes that followed were immediate and comprehensive. Brennan ordered his court staff to develop accommodation procedures that exceeded federal minimums while establishing veteran preference protocols that ensured military service would be recognized rather than questioned. The policies would become models for courts throughout the judicial district. General Hayes's role in the proceedings was formally recognized when Justice Gonzalez requested her assistance in developing federal guidelines for military-civilian cooperation in legal proceedings involving veterans. The partnership would influence how courts throughout the country approached cases involving service members and veterans. The legal resolution was swift and decisive, with Lisa's employer agreeing to immediate reinstatement, full back pay, and comprehensive accommodation that would allow Ranger access to all company facilities. The settlement included punitive damages that reflected the company's violation of federal law while establishing precedent for similar cases nationwide. But the most meaningful resolution was personal rather than legal. Lisa's dignity was restored not just through legal victory, but through recognition from the highest levels of American government that her service had earned protection rather than skepticism, accommodation rather than resistance. The media coverage that followed was extensive and influential, with Lisa's story becoming symbol of broader issues about veteran treatment and judicial accountability. The coverage focused on her courage and service rather than her disability, transforming public understanding of what combat veterans contributed to civilian society. The educational impact extended throughout the legal system as law schools incorporated Lisa's case into their curricula about disability law and veterans' rights. The case became required study for judicial training programs while influencing how courts approached accommodation requests from disabled veterans. The policy changes were equally significant, with the Administrative Office of the U.S. Courts implementing mandatory training programs for federal judges on veterans' issues and disability accommodation. The training used Lisa's case as central example of how judicial prejudice could violate constitutional rights while dishonoring military service. The personal healing that Lisa experienced was gradual, but complete. Her faith in civilian institutions restored through witnessing how courage and advocacy could overcome prejudice when supported by proper legal authority. Her relationship with Ranger was strengthened rather than damaged by their courtroom experience, proving that their partnership could function under the most stressful circumstances. The final ceremony was held 6 months later, when Lisa was awarded the Distinguished Public Service Medal by the Department of Veterans Affairs recognition for her role in advancing veterans' rights through her courage in challenging institutional discrimination. General Hayes presented the award while Justice Gonzalez provided remarks about constitutional principles and military service. Sometimes the greatest battles are fought not with weapons, but with dignity, Lisa reflected during her acceptance speech. Ranger and I didn't just win a legal case, we proved that veterans' rights mean something when defended by people who understand that service continues long after the uniform comes off. The courtroom that had once been a place of humiliation became a symbol of transformation, with Judge Brennan implementing changes that made his court a model for veteran accommodation and Disability rights. His era had become education that benefited thousands of future litigants who would receive the respect that Lisa had initially been denied. The Lisa Martinez case became a watershed moment for judicial treatment of disabled veterans and service animals, establishing legal precedents and training requirements that transformed how courts approached military service and disability accommodation. The comprehensive reforms that resulted influenced federal judicial policy and created standards that protected thousands of veterans from discrimination while honoring their service and sacrifice. The immediate consequences revolutionized Brennan's court and judicial district, with mandatory training programs reaching over 200 judges and court staff within 6 months. The investment in veterans' rights education exceeded $500,000 while preventing countless future incidents through enhanced understanding of military service and disability law. The training became mandatory for all federal judicial personnel, with Lisa's case serving as the primary educational example. The Supreme Court's involvement through Justice Gonzalez created constitutional precedents that strengthened enforcement of veterans' rights and disability accommodation throughout the federal court system. The constitutional principles established influenced major civil rights decisions while providing legal framework for protecting military service members and veterans from institutional discrimination. The federal policy changes included the Veterans Judicial Accommodation Act, which required specialized training for judges hearing cases involving veterans while establishing criminal penalties for judicial personnel who violated veterans' accommodation rights. The legislation created the first federal standards specifically protecting military service members and veterans in civilian legal proceedings. The American Bar Association adopted new ethical guidelines for attorneys and judges based on Lisa's case, with continuing education requirements that emphasized veterans' rights and service animal law. The professional standards influenced legal education nationwide while ensuring that future lawyers and judges understood their obligations to military service members and veterans. The judicial training revolution extended to state courts as the National Center for State Courts implemented similar programs based on the federal model. Lisa's story became required study for judicial education programs nationwide, while her advocacy work helped develop training materials that educated thousands of court personnel about veterans' issues and disability rights. The service animal protection movement gained national momentum through Lisa's case, with new legislation strengthening federal protections for service animal teams while increasing penalties for discrimination. The laws influenced state legislation and private sector policies that recognized service animals as essential medical equipment rather than pets requiring accommodation. The cultural impact transformed public understanding of veteran disabilities and service animal partnerships with Lisa's story, demonstrating that military service continued through civilian careers that utilized rather than abandoned combat experience. The case inspired broader conversations about veteran contributions and the obligations society owed to those who'd served in uniform. The educational legacy continued through the Lisa Martinez Center for Veterans' Rights at Stanford Law School, which provided legal assistance for disabled veterans while training future lawyers about military service and disability issues. The center became a national resource for veteran advocacy, while ensuring that Lisa's experience created lasting change in legal education. The enduring message transcended individual victory to encompass fundamental truths about American values. Military service deserved recognition rather than skepticism. Disability required accommodation rather than discrimination, and the strongest institutions were those that protected rather than persecuted those who'd sacrificed for their country.